Welcome to Chapter 10, Introduction to Contracts. Contracts make business matters more predictable and are integral to the day-to-day business and personal life. Understanding how contracts are formed, the rules of contract law, and remedies the law has created to address harm that can result when formal contract rules don't apply enables greater control over one's life. Lord Melbourne, a former British Prime Minister, said, "The whole duty of government is to prevent crime and to preserve contracts." Judicial restraint makes the law less flexible but more predictable. Judicial activism makes the law more flexible but less predictable. People make promises every day. The law will enforce some but not others. Why is this? What distinguishes a promise the law will enforce, like a contract, from a promise the law will not enforce? One way to begin to understand the differences between unenforceable promises and contracts is to pose common examples of the former and ask why the law would not enforce them. For example, suppose one student asks another student out on a date, say to attend a party this coming Saturday night. The invited student makes preparations for the date, buys clothes, gets a haircut, whatever fits the situation. The student who issued the invitation doesn't show up at the appointed time. Can the student who was stood up sue the other for breach of contract? Experience would tell you that the answer is of course not. But why is that so? This promise involves offer and acceptance. Would you like to go to this party with me on Saturday night? I'll meet you at your apartment at 10:30. Sure, that would be great. Consideration. Each party promises to do something he or she is not otherwise obligated to do, and each gives his or her promise in exchange for the other's promise. Contractual capacity makes the parties over the age of 18 to dispense with this issue, and a legal purpose. Why can't the disappointed student file a breach of contract lawsuit as soon as the courts open on Monday? Certainly one reason the law would not enforce this promise is that while there is an offer and acceptance, there is no intent to form a contract. These parties thought they were agreeing to go on a date, which does not create contractual expectations, whatever emotional expectations it may raise. However, if one changes the facts somewhat, a businesswoman is at an out-of-town conference and arranges for a male escort from a legitimate companionship service to attend a business social engagement, then fails to show up at the appointed time, the parties' expectations take on the aspect of contract. One purpose of contract law, then, is to distinguish unenforceable day-to-day promises from legally enforceable promises. Agreement means that one party must make a valid offer and the other party must accept it. Consideration means that there has to be bargaining that leads to an exchange between the parties. The contract must be for the lawful purpose for legality to exist. Capacity means that the parties must be adults of sound mind. Contracts are promises that the law will enforce. Common law once required that all contracts be in writing with the seal affixed. Later, some payment was required before a contract could be enforced. By the 1990s, courts began to consider the fairness of contracts before enforcing them. There are many different types of contracts: bilateral versus unilateral, express versus implied, executory versus executed, valid versus unenforceable versus voidable versus void. With bilateral contracts, both parties make a promise to do something to or for each other. With unilateral contracts, one party makes a promise to the other that the other party can accept only by doing something specific. With express contracts, the two parties to the contract explicitly state all of the important terms of their agreement. With an implied contract, the words and conduct of the parties indicate that the parties intended to make an agreement. Implied contracts can be difficult to understand, perhaps because the other paired terms introduced in this section present two phases of some aspect of contract, bilateral and unilateral, executory and executed. People do not enter negotiations with intent to form an implied contract. Implied contract is not another method of forming a contract, but a remedy a court may apply after the fact if there was no valid contract between the parties, but their words and conduct manifest implied intent that certain promises would be legally enforceable. An executory contract is when one or more parties has not fulfilled its obligations under the contract. An executed contract is when all parties to the contract have fulfilled their obligations under the contract. A valid contract is an agreement that satisfies the law's requirements. An unenforceable agreement is when the parties intend to form a valid bargain, but some rule of law prevents enforcement. A voidable agreement is when the law permits one party to terminate the agreement. A void agreement is one that neither party can enforce, usually because the purpose is illegal or one of the parties had no legal authority. In the case of DeMass versus the ITT Corporation, Roger DeMass and 5 others had been hourly employees at will at ITT for many years. ITT issued an employee handbook, which it revised 4 times over 2 decades. The first 4 editions of the handbook stated that within each job classification, any layoffs would be made in reverse order of seniority. The 5th handbook made 2 important changes. First, the document stated that the handbook did not guarantee continued employment. Second, the handbook stated that ITT reserved the right to amend, modify, or cancel the handbook, as well as any of all the various policies outlined in it. 4 years later, ITT notified its hourly employees that layoff guidelines for hourly employees would not be based on seniority, but on ability and performance. About 10 years later, the 6 employees were laid off, though less senior employees kept their jobs. The 6 employees sued. Do you think that ITT had the right to unilaterally change the layoff policy? The judgment was for the employees. The case came to the Arizona Supreme Court from the Ninth Circuit, which certified this question. Once a seniority layoff policy becomes part of the employment contract based on the employee's reliance on the company handbook, may the employer thereafter unilaterally change the handbook policy and lay off employees without regard to seniority? The Arizona Supreme Court said the answer was no. The court emphasized that an implied contract carries just as much force as an express contract. The manner of contract formation doesn't matter. Assuming that the handbook created reasonable expectations of a seniority layoff plan, it was binding on the company. The company then had no right to unilaterally modify the agreement. Even when there's no contract, a plaintiff may use promissory estoppel to enforce the defendant's promise if the defendant made a promise knowing that the plaintiff would rely on it, and the plaintiff did rely on the promise, and the only way to avoid injustice is to enforce the promise. Even when there's no contract, a court may use quasi-contract to compensate a plaintiff who can show that he gave some benefit to the defendant and that he reasonably expected to be paid for the benefit and the defendant knew it, and also that the defendant would be unjustly enriched if she did not pay. The damages awarded are called quantum meruit, meaning that the plaintiff gets as much as he deserved. Courts created promissory estoppel and quasi-contract as fallback remedies for cases in which the plaintiff cannot prove a valid contract with the defendant. They are not equivalent, however, to a claim of breach of contract for 2 reasons. Both require a plaintiff to convince the court, as an essential element of the claim, that justice requires a judgment for the plaintiff. And in both, a successful plaintiff will almost invariably receive a smaller award of damages than would be the case in a claim for breach of contract. Sources of contract law include common law, Uniform Commercial Code, and restatement of contracts. Article 2 of the Uniform Commercial Code governs the sale of goods. Goods means anything movable except for money, securities, and certain legal rights. In a mixed contract, Article 2 governs only if the primary purpose was the sale of goods. In the case of Fallsview Glatt Kosher Caterers Incorporated versus Rosenfeld, during the Jewish holidays, Fallsview Glatt Kosher Caterers organized programs at Kucher's Country Club where it provided all accommodations, food, and entertainment. Fallsview sued Willie Rosenfeld, alleging that he had requested accommodations for 15 members of his family, agreeing to pay $24,000 and then failed to appear or pay. Rosenfeld moved to dismiss, claiming that even if there had been an agreement, it was never put in writing. Under UCC Section 2-201, any contract for the sale of goods worth $500 or more can only be enforced if it's in writing and signed. Fallsview argued, however, that the agreement was not for the sale of goods but for services. The company claimed that because the contract was not governed by the UCC, it should be enforced even with no writing. Do you think that the agreement was for the sale of goods, requiring a writing, or for services enforceable with no writing? Rosenfeld's motion to dismiss was denied. Mr. Rosenfeld contends that the predominant purpose and main objective of the agreement alleged by Fallsview was the service of kosher food, while the hotel accommodations and entertainment were merely incidental or collateral services. The defendant argued that the essential religious obligation during the 8-day period and the principal reason why people attend events similar to the program sponsored by plaintiff is in order to facilitate their fulfillment of the requirement to eat only food which is kosher for Passover. It is the desire to obtain these goods and not the urge for entertainment or accommodations that motivates customers to subscribe to such programs. However, the review of the characteristic of Fallsview's daily activities program led the court to conclude that the essence of the family and communal experience was defined primarily by services and not by goods. If you understand the contract issues that courts scrutinize, the agreement you draft is likelier to be enforced. You thus achieve a greater control over your affairs, the very purpose of a contract. Congratulations on making it through Chapter 10 on contracts. After you read the text, you'll then be ready to complete your essay assignments, quiz, and discussion board.